The next area of the SRA curriculum that you need to know for the SQE exam is breaches of fiduciary duty. So we're going to start with the dealing rules. In order for a fiduciary to have breached one of their duties, they must have made a conscious decision rather than just an omission. If the breach is unconscious, then they will not be held responsible. However, a fiduciary who has consciously breached a duty but did not do so in bad faith will still be liable, as a breach is one of strict liability. Therefore, for a breach to occur, there must be a conscious decision, but there does not need to be ill intent. So what about the self-dealing rule? So this rule is relevant where a trustee may wish to purchase property from the trust. There is a clear conflict of interest here between the wishes of the trustee to get the cheapest price and that of the trust to get the best price for the property. Since the trustee themselves is the legal owner of the property, they would be able to manipulate the price to give them the most benefit, and the beneficiaries would lose out on value. So trustees are also not allowed to sell their own personal property to the trust. If a trustee breaches the self-dealing rule, then the whole transaction is immediately voidable. Liability is strict, and the courts are unwilling to consider if the trustee has actually gained any advantage. The reason for this was considered by Lord Eldon. This was in the case of ex parte James. He noted that this rule relied more on general principles rather than the circumstances of individual cases. The general interests of justice requiring it to be destroyed in every instance. Therefore, even if the transaction is completely honest, the beneficiary can insist on cancelling it. A trustee is also not able to retire in order to purchase trust property, as they will still be caught by the rule. The only ways that a trustee can make a voidable transaction into an authorised transaction is by court order, a specific provision in the trust instrument, or with the informed consent of all beneficiaries. So the fair dealing rule allows that where a trustee transacts with a beneficiary and purchases their equitable interest, that transaction is voidable unless the trustee can prove that they completed the transaction with all material facts known to the beneficiary. They must also show the transaction was fair and honest, and that there was no advantage taken by the trustee, and with the beneficiary using their own independent judgment. These criteria must be fulfilled, as there is a presumption of undue influence over these sorts of transactions. From what we've just learned, it should be clear that the fair dealing rule is a lot more relaxed than the self-dealing rule. It is likely that the reason for this is because the beneficiaries are aware of what happens with their beneficial interest, but may not always be aware of what happens with the legal property of the trustees. So here's an example to help clarify these principles for you. Shanice is a trustee over a trust which has various investments, one of which is a house valued at over $600,000. The beneficiary under the trust has just moved out of the house and wishes to sell it, but Shanice has had her eye on it ever since she became trustee and desperately wants to own it. The house has been on the market for over a year at $600,000 and has not yet attracted any bids. So Shanice bids $450,000 and purchases the property. She already owns the legal title, so it's an easy purchase. Now here she has fallen foul of the self-dealing rule, and the beneficiary is entitled to insist that the transaction be set aside. The trust would return the money she spent, and the house would be conveyed back into the joint names of herself and the other trustees. In another example, Shanice wished to purchase the equitable interest held by the beneficiary in a set of company shares that are valued at $100,000. In order for this transaction to be valid, she would need to prove that the beneficiary was fully aware of all the facts of the transaction and that Shanice was acting honestly and had not taken any advantage of her position to pressure the beneficiary. If she was able to do this, then the transaction would be valid, but this is hard to show. So what kind of question could you get in the SQE exam on this? Let's consider an example. Lisa is a trustee for a trust which owns a property valued at £1 million. It has been on the market for about a year and a half and has had no offers. So Lisa makes an offer at $850,000 and purchases the house. Before she did, she talked to the beneficiaries and said she had a buyer who wanted to purchase the house, and they agreed. Has there been any breach of trust here? Yes, she has fallen foul of the fair dealing rule. No, because she got the consent of the beneficiaries. Yes, because she did not bid 1 million. Yes, because she's fallen foul of the self-dealing rule. No, because the house had been on the market for more than a year. The correct answer is D. Yes, because she's fallen foul of the self-dealing rule. So by way of explanation, D is the correct answer because she has purchased property from the trust, which has strict liability. Answer A is wrong because this is not concerning the purchase of equitable interest. Answer B is incorrect because their consent was not fully informed. She didn't say who the buyer was, in other words, that it was her. Answer C is wrong because no matter how much she bid, this would still be a breach of trust. Answer E is incorrect because the length of time does not matter.